Okay, Assalamualaikum warahmatullahi wabarakatuh. My name is Nadine bin Anafi and I'm from 6P. Okay, today our group will present about duty of care. Okay, first, present about introduction. The first of the major components of thought duty of care, breach and causation is the duty of care. Although there are many circumstances in which someone may act negligently, no claim will be made unless there is an obligation of care owed to the person who was harmed as a result of the negligent act. The case or the problem will fall short if the duty of care was not present at the time of the violation, and this is the main point. Although the phrase duty of care may first seem strange, but it can be loosely defined as the responsibility of an individual not to cause damage to others through negligence. For instance, it is the duties of a motorist to avoid reckless driving that could endanger the other road user. In other words, they owe the other users of the road as a responsibility of care. The duty of care is frequently viewed as a control mechanism in law because it has the power to make or break some cases. In essence, this means that it allows courts to distinguish between the cases that are legally significant and merit further investigation from those that do not. Okay, that's all for me. Next to the other presenter.
My name is Ahmad Karul Nizam bin Basiran. So we go for duty. Duty means an obligation or a burden imposed by law which requires a person to conform to a certain standard of conduct. The issue arose on how to determine the existence of this duty, who should be responsible, and to what extent the duty can be imposed. Thus, the neighbor principle is the principal test used to determine the presence of a duty of care. The rule that you are to love your neighbor become law. You must not injure your neighbor, and the lawyer's question, "Who is my neighbor?" receive a restricted reply. You must take reasonable care to avoid acts and omission that you can reasonably foresee would be likely to injure your neighbor. The neighbor principle laid down in the case Donoghue vs. Stevenson provide the basis and conceptual cornerstone for the development of the law of negligence in the 20th century. In this case, a friend of the plaintiff had purchased for her a bottle of ginger beer at a cafe. The ginger beer bottle were opaque and the plaintiff was unable to see their content. When the plaintiff friend refilled the glass, along with the ginger beer came the decomposing remains of a snail. So, the plaintiff suffered shock and subsequently became ill. She sued the manufacturer for negligence as the bottles should be carefully inspected before they were filled with the drinks. The House of Lords held that the defendant, being the manufacturer of the ginger beer, owed a duty of care to the plaintiff as the ultimate consumer of the drink. This duty was to take reasonable care to ensure that the bottle did not contain any substance that was likely to cause injury to anyone who purchased in due course.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Ahmad Hakimi bin Muhammad Azli. Today I will present about the neighbor principle. Okay, this is a principle. However, need to be applied on the case as there are so situation in which the law deny the duty. For instance, if this is A did not want B, then so was not typed up. He cannot then be responsible if B fault of injuring himself. Okay, you have your own liberty and conscience as to whether to want that person or not, because it's your own choice. The law will not impose a duty on the skin of situation. The law only recognizes the neighbor principle at the internal point determining the extent of the duty of a care in classic and normal situation. Okay, in home office with Das Yacht Company Ltd, the neighbor principle was used to ascertain the instance of the duty of the care. Okay, in this case, 7-year-old boy had escaped from an island where were undergoing training. The escape was due to the neglect of the Boston office, who contrary to order were in bed. The escape caused damage to yacht, and the owner commented the action for neglect against the home office. It was held that the home office on a duty of the care for omission, as they were in a position of a control there. In nature of a result from the qualification in the unless the neighbor principal knew circumstance read state the principle required. The time has come when we can say there is on to apply some justification, a valid explanation for its exclusion. Is the clear that the key simple stood as the sovereign guarding authority is the title of this work as for discussion as the whether the precedent indicate basis on which to resolve duty of care question, and is offering by subsequent judicial discussion of the issue. The field of law, however, that so saying the Donoghue provide the answer to that question suggestion made by Lord Ring Home Office with thus judge finally led to the decision method. The case had developed a new test as the made in ends versus Lord Ambrose, or extraction from the home test now and test. That's all for me. Thank you.
Assalamualaikum, my name is Abdul Ghafur. Today I will present about N-test. This standard was developed by Lord Wilberforce after Ants vs London Borough of Merton Act. The plaintiff lived in a residential building as tenant. Due to insufficient foundation that were just 2 feet 6 inches deep instead of the statutory minimum of 3 feet. The flats had structural flaws. The defendant municipality was in charge of checking the apartment foundations as they were being built. The defendant did have a duty of care to make sure that the foundation were the proper depth. The House of Lords unanimously decided. First, responsibility of care. Secondly, one must determine if there is a sufficient link of closeness or neighborhood between the accused offender and the person who has been harmed, such that in the reasonable contemplation of the former, negligence on his part may be anticipated to cause injury to the latter. If the answer is true, a basic obligation of care arises. Second, policy. If the first question is answered in the positive, it is next required to determine whether there are any factors that should be eliminated, limited, or reduced in terms of the duty scope, the class of people to whom it is owed, or the damages that a violation of it may cause. The N case and the Donoghue versus Stevenson case do have certain similarities, as can be shown. In both instances, critical examination was conducted before the production of items for end consumers. The plaintiff in the Dono case said that the ginger beer bottles should have undergone a proper examination before being filled with liquid since she had incurred bodily injury. The plaintiff sustained bodily harm because to the manufacturer's carelessness. The tenants of the house in the instance argued that the respondent counsel should have conducted the appropriate examination of the flat's foundation. The plaintiff experienced property loss a result of the council's carelessness in conducting the inspection. Yet the plaintiff in the Dono case experienced bodily harm, but the plaintiff in the Ends case may only be claimed to give suffered economic loss. Because of this, the Ends test appears to provide the victims with greater protection than they should. Thank you.
Okay, next is me. In the case of Duton versus Bognor Regan Urban District Councils, Mrs. Duton claimed damages against the local council, Bognor Regan Urban District Council, and the builder, Bognor Regan Building, who had certified that her home was structurally sound. Yet it became apparent that because her home was built on a landfill, the foundation were flawed. If the appropriate checks had been done, the handicap would have been found after learning that a negligence claim could not be successful. Mrs. Duton resolved the claim with the builder for £635. Nonetheless, she pursued her lawsuits against the council and was given a £2,115 damages award by the judge. The council filed an appeal with the Court of Appeal, and the court upheld the precedent established in Dakwe vs. Stevenson by ruling that Mrs. Duton may pursue financial compensation from the councils. Spontaneity to a lawyer by letter of a home that a surveyor had carelessly certified as being in excellent condition was fair and reasonable. Similar circumstances to the Ants case is in other instances. As we can see, the closeness relationship has grown before the Donghui case. We might have been able to observe the close relationship between the maker and the store and the retailer and the clients. Yet many negligence claims would have been unsuccessful if the person dealing had only been restricted to near proximity. Because of this, Mrs. Duton in the Bognor case was informed that her lawsuits against the builder would fail. In reality, she could have been sued for the council for damages, even though it seems to be further removed from her than the builder was. So we may draw the conclusion from the defendants are accountable for their careless activities in situation involving pecuniary loss as long as the plaintiff were harmed by the defendant's action. In order to prevent any responsible harm to the customers, we can assure that manufacturer and governments, organizations in charge of regulation products standards will carry out their duties correctly by applying the regulations learned from the case. If we give those involved as the main level of a problem just a share of responsibility, there will be a few issues. As a result, if the standards were to apply to all situations of carelessness, it will be difficult for the government to come up with a policy that will appear to be a wolf in sheep clothing while yet protecting the public interest. But when the lawsuit involves the government will form win since they have their own status, they respect, they limit their accountability for their own careless action. In the end, some issues have been decided by our government body rather than the legal system. Furthermore, this explains why the comparator test has been favoured by the Malaysian courts, while the Ant test has been dismissed. Jobling versus Associate Dairies, according to Lord Wilson, the common law and its logical principles do not entirely regulate in reality which we live in, nor broad, rational, or impartial standards that apply to all. In a way that is consistent with justice can be articulate. And that's all for me. Next to the next presenter.
Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Firdaus bin Muhammad Fauzi. So the second stage is based on whether there is a close relationship between the defendant and the claimant. This does not specify that there must be physically distance between the claimant and the defendant, but rather that there must be a relationship between the two. An example of proximity, or rather lack of proximity, can be seen in Alcock versus Chief Constable of South Yorkshire Police 1991. UKHL 5, a member of the public who came across after the Hillborough disaster and suffered a nervous breakdown as a result, was deemed not owed a duty of care by the defendant because the relationship between the defendant and the claimant is considered too distant. The third and final stage of caporal involves determining whether it is fair, just, and reasonable for the court to find that the defendant owed a duty of care to the claimant. Due to the ambiguous nature of this criteria, this stage can be regarded as a safety valve, allowing judicial discretion in case where public policy may dictate that it is unreasonable for a duty of care to be held. Example of application of the criterion can be seen in cases such as Marsh and Co. versus Bishop Rock Marine at 1995. UKHL, a ship surveyor negligently carried out a safety survey on a ship which subsequently sank. The court found that it was not only for a duty of care. Despite finding both forcibility and immediacy, the court notes that it was industry standard for such a claim to be settled between the cargo owner and the ship owner, both carrying insurance for the purpose. Therefore, it was decided that it would be unfair to place the liability on the safety surveyor. Although there are a number of clear cases where this stage can be used to defeat a claim, it is worth noting as in X Minor versus Bedfordshire Council at 1995 to AC 933 at 749, that the presumption will normally be that this stage will pass unless there is a convincing precedent. Conclusion: so if these three stages are passed, the case can be said to have met the caporal test, and thus a duty of care can be said to exist. Thank you.
My name is Muhammad Fikri Z. Today I want to tell you about the caporal industry v. Dickman. The caporal test consists of the three levels: predictability, clones, and equality. This first stage revolves around whether it was feasible that the defendant negligent could cause damage to the claim. A prime example of the possibility can be seen in the as-based, the case of the paragraph v. Long Island Railroad Co. In the case, the defendant drops a box of fireworks, which cause an explosion, which in the turn cause a set of heavy metal scale to fall on the defendant negligent. The court denied the claim in applying the possibility the test, and the court found that it was not possible that the claim will be injured. On the other hand, consider what would have happened if the claim had been injured by the explosion itself. It quite possible that dropping fireworks of the type described in 1928 would be cause an explosion, and that explosion might injure someone standing close enough. If the is the case, then the court might find the harm was feasible. Next presentation.
And lastly, conclusion. In conclusion, different strategies have been used to resolve the question of negligence and the obligation of care. The courts have found it advantageous to create a new categories of negligence by drawing the precedent set of clear cases, as evidenced by the rejection of the two steps in ends and decisions in subsequent cases. The three-stage established in Caparo versus Dickman, forcible of harm, proximity of connection, and just reasonable to impose a duty, is now generally accepted as the general rule when there is no precedent ready. The formulation consists the matter in a lot in civil engineering and building contract. Okay, that's all from our group. Thank you.